Well, good morning, ladies and gentlemen. For those of you who don't know me, my name is Grantham QC, and I shall be speaking this morning on business interruption and coronavirus, specifically the decision of the Supreme Court in the Financial Conduct Authority and Arch Insurance. Speaking also this morning will be Professor Andrew McGee, author of a leading work on insurance law, and he will be speaking on causation and the FCA response to the decision. If you'd like to ask any questions, please use the chat facility accompanying Zoom, and copies of our notes and slides will be distributed at the conclusion of our talk. One of the many issues that is likely to arise out of the current coronavirus pandemic is the extent to which an insured may be entitled to claim an indemnity on its insurance policy in respect of the interruption of its business. Business interruption cover is provided upon the occurrence of a specific insured event. The wording of each policy will therefore be critical. Often, business interruption policies will provide an indemnity where financial losses are suffered by a business consequential upon material damage to property. Such policies will not provide an indemnity where businesses are affected solely by reason of the consequences of responses to the pandemic. However, certain policies provide cover independently of any material damage to property, often by way of an extension to damage cover. As might be expected, clarity as to entitlement to recover under such policies has become extremely pressing. A test case, therefore, was brought by the Financial Conduct Authority and Arch Insurance UK Limited, and others, to determine issues of principle in relation to policy coverage under various specimen policy wordings underwritten by the defendants that potentially provided an indemnity for BI losses arising in the context of the Covid-19 pandemic and legislative and administrative responses thereto. On the 15th of September of last year, the Commercial Court handed down judgment at first instance. The FCA and several insurers appealed directly to the Supreme Court in respect of certain of the issues, and the court handed down judgment on the 15th of January of this year. The majority judgment on which I shall concentrate was given by Lords Hamblin and Leggett, with whom Lord Reid, the President of the Court, agreed. Lord Briggs gave a judgment with which Lord Hodge agreed, which reached the same conclusion, but by an additional route. Numerous different policies within each category were considered, and the only reliable basis on which to advise your clients is the careful consideration of the lengthy judgments, which run to no fewer than 326 paragraphs. That said, it is hopefully possible to identify some general principles which may at least provide some assistance to you. The majority judgment in the Supreme Court addressed, and this talk will therefore address, the following principal issues. First of all, the factual background, including the government measures and categories of business affected. Secondly, the insured peril in respect of disease, prevention of access and hybrid clauses. Thirdly, causation. Fourthly, trends clauses. Fifthly, pre-trigger losses. And finally, the status of the decision in a case called Orient Express Hotels and Generali. Overall, the Supreme Court upheld the appeals of the FCA, albeit in qualified terms on two issues, and dismissed the insurers' appeals. Key events. The judgment first set out the history of a pandemic insofar as it was relevant to the determination of the issues before it. Of particular importance are the following key dates. On the 12th of January, the World Health Organization announced that a novel coronavirus had been identified in China. On the 31st of January, the Chief Medical Officer for England confirmed that 2 patients had tested positive for COVID-19. Cases were confirmed in Wales and Northern Ireland in February and in Scotland in March. On the 10th of February, the Health Protection Coronavirus Regulations 2020 were made by the Secretary of State for Health and Social Care, pursuant to powers under the Public Health Control of Disease Act 1984. On the 4th of March, the UK government published guidance in respect of social distancing. On the following day, COVID was made a notifiable disease, and SARS-CoV-2 was made a causative agent in England by amendment to the Health Protection Notification Regulations 2010. The same occurred in Wales on the following day. On the 11th of March, the WHO declared COVID-19 to be a pandemic, and on the 12th of March, the UK government announced that it was moving from the contain to the delay phase of its action plan and raised the risk level to high. On the 16th of March, the UK government provided guidance on social distancing for vulnerable people, and the Prime Minister made a statement advising the public to stop non-essential contact and travel. Further guidance was given by the Prime Minister 2 days later, in which statement he announced the closure of schools on the 20th. On that day, the PM said that further steps were required and indicated that hospitality, exercise and entertainment values were being told to close as soon as they reasonably could. On the 21st of March, the Health Protection Coronavirus Business Closure England regulations and equivalent regulations for Wales were made. The 21st of March regulations provided for the closure of businesses set out in the schedule to those regulations. Under Regulation 2.1, the businesses listed in Part 1 of the schedule, comprising restaurants, cafes, bars and public houses, were required to close or cease carrying on the business of selling food and drink other than for consumption off the premises. Regulation 2.4 required the businesses listed in Part 2 of the schedule to close. They included cinemas, theatres, nightclubs, bingo halls, concert halls, museums, and other similar establishments. Regulation 3 made contravention of Regulation 2 a criminal offence. On the 23rd of March, the PM announced that the population must stay at home and the closure of all shops selling non-essential goods and other premises, including libraries and outdoor gyms. Further guidance was issued on the same and the following day. On the 25th of March, the Coronavirus Act 2020 was passed, and on the following day, the Health Protection Coronavirus Restrictions England Regulations 2020 were made, largely replacing the regulations made on the 21st of March, and similar regulations were made for Wales. Those regulations were amended on several occasions, and I shall refer to them in this talk as the regulations. On the 4th of July, the regulations were revoked prospectively and replaced with more limited restrictions in the Health Protection Coronavirus Restrictions No. 2 England Regulations 2020. Categories of business. Within the judgment and based on the regulations, a categorization of various types of business was adopted as follows. First of all, Category 1. They were businesses listed in Part 1 of Schedule 2 to the regulations, such as pubs, bars, cafes and restaurants, which were all affected by Regulation 4.1. Category 2, businesses listed in Part 2 of Schedule 2, such as cinemas, theatres, nightclubs, indoor gyms, beauty salons, spas and car showrooms, affected by Regulation 4.4. Category 3, businesses listed in Part 3 of Schedule 2, referred to as essential shops, such as food retailers, off-licenses, pharmacies, petrol stations, and car repair services, excluded from the scope of Regulation 5.1 of the regulations. Category 4, businesses offering goods for sale or hire in a shop or providing library services, referred to as non-essential shops, not listed in Part 3 of Schedule 2 to the regulations and affected by Regulation 5.1. The fifth category were businesses not referred to in the regulations at all, including professional service firms as well as construction and manufacturing undertakings. Category 6 were businesses providing holiday accommodation, affected by Regulation 5.3 of the regulations, and finally Category 7, places of worship, affected by Regulation 5.5 of the regulations, together with nurseries and schools. In this section of the talk, I'm now going to address one of the principal issues of which the Supreme Court determined, that is coverage. In addressing issues of coverage, the court identified three groups of policies depending upon the nature of the insuring clause. The first category was disease clause policies, essentially being non-damage extensions to the standard business interruption cover, requiring the presence of a defined disease on or within a stated radius of the insured premises. Second category was prevention of access and similar clauses. Those were policies where the insuring clause provided cover where there was a prevention or hindrance of access to or use of the insured premises as a consequence of government or local authority action or restriction. And thirdly, hybrid clause policies. That is those where the insured peril was defined by reference both to restrictions on the premises and to the occurrence or manifestation of a notifiable disease. So first of all, disease clauses. The Supreme Court proceeded to determine issues of cover by reference to specific policy wording of policies underwritten by Argenta, MS Amlin Underwriting, QBE, and RSA. And the court used the wording of an RSA policy, specifically RSA 3, as an exemplar. And you can see the wording insofar as it's relevant on the slide. Typically in disease cases, the basic cover provided by such policies in Section 1 is the business interruption, but as a consequence of physical loss or destruction of or damage to property under the property damage section of a policy. However, Section 2 provides a series of extensions which provide cover for business interruption that is not so consequent. The relevant extensions are in respect of disease. Insofar as material, the RSA 3 extension provided cover in respect of business interruption or interference during the indemnity period following any occurrence of a notifiable disease at or within a radius of 25 miles of the premises. Notifiable disease was defined, insofar as material, as illness sustained by any person resulting from any human infectious or contagious disease, an outbreak of which the competent local authority had stipulated should be notified to them. Indemnity period was defined as the period during which the results of a business were affected in consequence of the occurrence, beginning with the date of the occurrence. The Supreme Court first recorded 3 agreed matters. First, by the 6th of March of last year, COVID fell within the description of notifiable disease. That is a disease notification of which was required by the Health Protection Notification Regulations 2010. Second, for illness resulting from COVID to be sustained by any person, it was sufficient if a person had in fact contracted the disease, irrespective of whether that had been symptomatic or diagnosed. Their presence was relevant only to proof. And third, the word following denoted some causal and not merely temporal connection. The court went on to consider the definition of a peril in the insuring clause, specifically what was meant by the words, any occurrence of a notifiable disease within a radius of 25 miles of the premises. At first instance, the commercial court held that the peril was the notifiable disease of which the individual outbreaks form indivisible parts. It thus read the words any occurrence of a notifiable disease within a radius of 25 miles as meaning a notifiable disease of which there is any occurrence within a radius of 25 miles. Alternatively, although the commercial court regarded this analysis as less satisfactory, it held each of the individual occurrences of the disease to be a separate but equally effective cause of the business interruption. The majority of the Supreme Court rejected the commercial court's primary interpretation of the insured peril. It did so on the basis that it amounted to holding the peril to be the disease itself, whenever and wherever it occurred, provided that there was a single occurrence within the relevant radius, with the cover running from the date of the local occurrence. Rather, the majority of the Supreme Court held that there had to be an occurrence of illness resulting from COVID sustained by a particular person within the specified radius. In insurance law, an occurrence, like its synonym event, had a well-established meaning, namely something which happens at a particular time, at a particular place, in a particular way. That was reinforced by the definition of the indemnity bid, which was defined so as to begin on the date of the incurrence. The insured peril was, therefore, business interruption caused by any cases of illness resulting from COVID that occurred within a radius of 25 miles of the premises from which the business was carried on. The court came to a similar conclusion in respect of a similar wording in the Argenta, MSA, and QBE policies. The same conclusion was also reached in respect of one of the QBE policies, which defined the insured peril as any human infectious or contagious disease, an outbreak of which the local authority had stipulated should be notified to them, manifested by any person while in the premises within a 25-mile radius. In each case, the insured peril extended to the relevant effects of COVID at or within a specified radius of the insured premises. The court had little difficulty in rejecting RSA's contention that an exclusion for epidemic and disease cut down the cover provided. This interpretation of the insured peril gave rise to obvious issues of causation, with which the commercial court was not faced, and to which I shall turn when addressing issues of causation generally. I'm now going to turn to the coverage in prevention of access and hybrid policies. First of all, prevention of access policies, which defined the insured peril by reference to interference in the use of the insured premises due to public authority action. An example of a prevention of access clause was the ARCH policy, which is shown in your slide. It provided cover against loss resulting from prevention of access to the insured premises due to actions or advice of a government or local authority due to an emergency which was likely to endanger life or property. Hybrid policies include as one element of the insured peril the requirement for a notifiable disease that in some way was connected with the interference. An example was the Hiscox policies. They provided cover against losses resulting solely and directly from an interruption to activities caused by your inability to use the insured premises due to restrictions imposed by a public authority during a period of insurance following an occurrence of any human infectious or human contagious disease, an outbreak of which must be notified to the local authority. In the case of Hiscox 4, the occurrence of a notifiable disease also had to be within 1 mile of the business premises. In each case, it was held that the policies provided for a composite peril, that is, a series of requirements, each of which had to be satisfied for cover. The Supreme Court proceeded to consider the various elements in turn. First of all, the disease elements in hybrid policies. The Supreme Court held that the word occurrence had to be interpreted in the same manner as that for disease policies. That is, something that occurred at a particular time, at a particular place, and in a particular way. Each individual case was properly regarded as an occurrence. In respect of Hiscox 1 to 3, where there was no express geographical restriction, the Supreme Court held that there was no requirement for the occurrence to be at or near the insured premises. Rather, the policy provided cover against the consequences of the occurrence of COVID, irrespective of where they occurred. The force of law point. The Hiscox policies required the business interruption to be due to restrictions imposed by a public authority. The commercial court held that that requirement entailed a mandatory restriction which had the force of law. Similar wording was included in other policies, for example RSA 1, which referred to closure or restrictions placed, and RSA 4, which referred to enforced closure. The FCA wished to argue that none of those policy wordings required measures which had the force of law. The practical significance was that it and the Hiscox interveners wished to contend that cover commenced before the 21st of March, which you'll recall was the date when the first set of regulations were made. The court held that the word imposed of itself did not require a valid legal basis for a restriction or the immediate prospect of one. Specifically, an instruction given by a public authority might amount to a restriction imposed if, from the terms and content of the instruction, compliance with it was required without the need for recourse to legal powers. Such an instruction would need to be mandatory and sufficiently clear to enable the addressee to know with reasonable certainty what compliance was required. In relation to RSA 4, however, the Supreme Court agreed with the court below that enforced closure of an insured location would not include advice or exhortations on social distancing and stay-at-home restrictions. The next issue is the nature of the restriction. The court dismissed Hiscox's appeal, upholding the commercial court, in holding that restrictions imposed did not need to be directed to the insured property or its use by the policyholder. Therefore, businesses falling within categories 3, that is essential shops, and category 5, businesses not referred to in the regulations, were subject to restrictions imposed, even though they were permitted to remain open. Inability to use. The court agreed with Hiscox that inability to use denoted a complete inability of use. However, that would be satisfied if the policy holder were unable to use the premises for a discrete part of its business activities. For example, a bookshop that was only able to use its premises to process telephone orders, or were unable to use a discrete part of its premises for its business activities. For example, a department store that was required to close all parts, save for a pharmacy. In both those situations, there would be a complete inability of use. In the first situation, there would be a complete inability to carry on a discrete business activity. In the second situation, there would be a complete inability to use a discrete part of the business premises. There might also be cases where both situations arose. For example, a golf course where the clubhouse had to close. In that case, there would be interference of a part of the property and also a part of the business activities. The FCA accepted that there was only cover for that part of a business for which the premises could not be used. Therefore, if a restaurant were required to close down its eat-in service but continued to provide takeaway food, the claim would be limited to the losses due to interference with the eat-in service only. Thus, by way of summary, the appeal of the FCA and the Hiscox interveners was upheld to the extent that an inability to use might include a policyholder's inability to use either the whole or a discrete part of its premises for either the whole or discrete part of its business activities. That said, it remained doubtful whether businesses falling in categories 3 or 5 would be able to demonstrate the requisite inability, because inability did not include hindrance or disruption. And for that reason, Regulation 6 of the regulations, which merely introduced a prohibition against people leaving the place where they were living without reasonable excuse, would rarely suffice. The next term considered was prevention of access. The policies underwritten by Arch included in the definition of insured peril prevention of access. The commercial court held that nothing short of complete closure constituted prevention of access. The Supreme Court held, for essentially the same reasons as it had applied in the context of inability to use, that access could be prevented to a discrete part of premises or to premises for the purposes of carrying on a discrete part of the business activities of the policyholder. In each case, access could be completely prevented rather than merely hindered, which would not suffice. For the same reason, businesses falling in categories 3 and 5 would rarely be able to demonstrate a prevention of access. Finally, in this section, interruption. The court dismissed Hiscock's appeal against the Commercial Court's ruling that interruption might extend to interference or disruption, not just complete cessation. Causation. The Commercial Court's conclusion as to the insured peril in disease cases, that is the COVID pandemic itself, provided that there was an instance within the stipulated radius, meant that issues of causation didn't materially arise. After all, if the insured peril were COVID, all the business interruption losses would be suffered by reason of the outbreak. It has been said most famously by Justice Oliver Wendell Holmes that hard cases make bad law. Whether or not that is true of the decision of the Supreme Court is probably above my own pay grade. However, what is certainly true is that the definition of the insured peril in the disease and hybrid policies as being or including the occurrence of COVID within the 25-mile radius gave rise to difficult issues of causation which are likely to have wider implication. The Supreme Court began its consideration of causation by embarking upon a lengthy consideration of causation in general, with particular reference to insurance, from which the following points emerge. The issue of causation in insurance, that is the degree of connection required between the occurrence of an insured peril and the loss against which the insurer agrees to indemnify the policyholder, is rarely to be determined by a minute analysis of the linguistic meaning of the words used in the policy, but rather the legal effect of the insurance contract as applied to a particular factual situation. No real difference would be indicated between words such as following, as a result of, arising from, or in consequence of. The contrast with the court's analysis of the insured peril is perhaps worthy of note. However, the court went on, the policy wording might sometimes indicate a looser degree of connection than normally required, by use of wording such as directly or indirectly caused by. Secondly, the test of proximate causation set out in section 55(1) of the Marine Insurance Act 1906, applicable to both marine and non-marine insurance, subject to contrary policy wording, was not concerned with the immediate cause of a loss, but rather the efficient cause, that is, with the agency of change. The starting point for the inquiry was to identify, by interpreting the policy and considering the evidence, whether an insured peril had any causal involvement in the loss, and if so, whether a peril excluded or accepted from a policy also had any involvement. Whether either peril was a proximate or efficient cause would be determined by answering the question whether the peril made the loss inevitable in the ordinary course of events. For these purposes, human actions were not generally regarded as negativing causal connection, provided the actions were not wholly unreasonable or erratic. Subject to the express wording of a policy, where there were two perils which were concurrently proximate causes of the loss, that is, perils that were in combination efficient causes of the loss, the policyholder would be covered unless one of the two perils were expressly excluded. Therefore, if the loss were caused by an insured peril and an excluded peril, generally the excluded peril would prevail and no cover would be provided. But if there were an insured peril and a peril for which the policy did not provide, generally the insured peril would prevail and cover would be provided. That analysis could be applied equally to multiple causes that in combination were the proximate cause of a loss. Applying that to COVID, it could not be said that any individual occurrence of the disease brought about the governmental restrictions on business activity. The governmental restrictions were a response to, and therefore caused by, all the occurrences of COVID in the country as a whole. Each occurrence was an equal cause of the imposition of the national measures. For a peril to be a proximate cause of loss, it would generally be necessary, but not sufficient, to show that the peril was a necessary or but-for cause of that loss. However, that would not always be the case. Proximate cause might be sufficient, but not necessary. An obvious example would be two fires which combined to burn down a property. Neither fire could be said to be necessary if each would have been sufficient to burn down the property. However, each might properly be said to be a proximate cause of a loss. Sometimes an event which was neither necessary nor sufficient might be a proximate cause. Let us take as an example where 20 businesses discharge effluent into a river, causing loss to a fish farm, when the discharge by 13 would have been sufficient, but the discharge by any one of them would not. Each business would generally be regarded as an efficient cause of the loss, but none was either a necessary or a sufficient cause. If an event had to be a but-for cause in order to qualify as an efficient or proximate cause, neither the fires nor any of the businesses involved would be regarded as an efficient cause of a loss. The court viewed such analysis as absurd. It noted that there was some support for rejecting the requirement for but-for causation in the insurance context, in the form of cases in which an insured was entitled to cover in respect of defence costs in respect of insured claims, notwithstanding the existence of uninsured claims for which the same costs were incurred. The Supreme Court then went on to hold that there was nothing in principle or in the concept of causation that precluded an insured peril in combination with many other similar uninsured events, bringing about a loss with a sufficient degree of inevitability from being a proximate cause of a loss, even if the occurrence of the insured peril was itself neither a necessary nor sufficient cause of a loss. Rather, the sufficiency of the connection depended on what had been agreed in the policy. Turning then to disease policies, the Supreme Court identified the question in each case to be whether the insured peril caused the business interruption losses sustained by the policy holder within the meaning of the causal requirements specified in the policy. Taking the policy wording in MSA 1, the question would be whether the interruption of a policyholder's business occurred following illness sustained by any person resulting from COVID within a 25-mile radius of the premises. The court concluded that a proper interpretation of the disease policies in order to show that loss from interruption of the insured business was proximately caused by one or more occurrences of illness resulting from COVID within the stipulated area, it was sufficient to show that the interruption was caused by government action taken in response to cases of disease, including at least one case within that geographical area, for example, a 25-mile radius of the insured property. That was on the basis that each occurrence was a separate and equally effective cause of that action and was irrespective of the precise causal connection stipulated in the policy. Therefore, it applied where the connection required was following, arising from, or as a result of. Turning to prevention of access and hybrid clauses, the Supreme Court applied the same analysis to hybrid causes, which contained as one element of the insured peril an occurrence of an infectious disease within a specified distance. In order to obtain cover, it would be sufficient to show that interruption was caused by closure or restrictions placed on the premises in response to cases of COVID, including at least one case manifesting itself or occurring within the specified radius. In these policies, establishing the insured peril typically requires proof of a number of elements. Thus, the Hiscox policies required proof of A, an occurrence of a notifiable disease, causing B, restrictions imposed by a public authority, causing C, an inability to use the insured premises, causing D, an interruption to the policyholder's activities that was the sole and direct cause of financial loss. The court below identified the peril to be a composite one comprising three elements: inability to use the premises due to restrictions imposed by a public authority following an occurrence of an infectious or contagious disease, and therefore held that in order to construct the relevant counterfactual, one had to strip out each of those three elements so as to ask what would have happened if none of those elements had occurred. The Supreme Court rejected that analysis on the basis that that would be to treat the insured peril as being not the risk of all the elements occurring in causal sequence, but the risk of any one or more of the elements occurring. In each case, the Supreme Court held, the same error had been made. The correct counterfactual was not what the financial position of the business would have been but for the occurrence of the insured peril. That would be to limit the indemnity to loss, the sole proximate or effective cause of which was the insured peril. However, the cover was provided against losses proximately caused by an insured peril, along with other perils which are not excluded and which the parties to the insurance would naturally expect to occur concurrently with the insured peril. In other words, the other consequences of the pandemic. Therefore, the public authority clause in the Hiscox policies indemnified the policyholder against the risk, and only against the risk, of all the elements of the insured peril acting in causal combination to cause business interruption loss. However, it did so regardless of whether the loss was concurrently caused by other uninsured but non-excluded consequences of the COVID pandemic, which was the underlying or originating cause of the insured peril. The same reasoning applied to the arch prevention of access policies, where the insured peril required proof of loss caused by prevention of access to premises, caused by the actions or advice of a government or local authority, caused by an emergency likely to endanger life or property. Once that peril was established, cover was provided for the loss caused by that peril concurrently with other non-excluded perils arising out of the same underlying or originating cause, that is COVID. It also applied to the RSA hybrid policy, where the peril contained two elements. First, closure or restrictions placed on the premises as a result of, two, a notifiable human disease, manifesting itself within a radius of 25 miles. Take a restaurant forced to close due to COVID within 25 miles of the premises. Its turnover might have been reduced anyway due to governmental or other measures following COVID. While those measures were not an insured peril, they were not excluded either. They were thus a concurrent cause. Each of those causes was sufficient to cause the loss and arose out of the same underlying or originating cause. Such loss would be covered. Finally, trends clauses. The question was whether the trends clauses operated so as to exclude losses that would have arisen notwithstanding the occurrence of the insured peril by reason of the wider consequences of the COVID pandemic. In other words, whether such clauses affected the analysis in the previous section of the judgment. In BI policies, the amount of the indemnity is typically quantified by comparing the revenue or profit in a period prior to the occurrence of the insured peril with the equivalent in the indemnity period. However, normally policies will contain a so-called trends clause, the wording of which will seek to adjust the amount of indemnity to reflect any special circumstances or business trends affecting the business either before or after the loss, so as to ensure as near as possible the indemnity reflects the result that would have been achieved if the insured peril had not occurred. The Supreme Court made a number of general points about trends clauses, which can be summarized as follows. First, they are part of the contractual machinery for quantifying loss rather than delineating the scope of the indemnity. Second, they are to be construed consistently with the insuring clause, and therefore, unless the policy wording so required, they would be construed so as not to take away the cover provided by the insuring clauses. In particular, therefore, they would be construed so as not to take away losses covered by the insuring clauses on the basis of a concurrent cause of those losses, which do not prevent them from being covered by the insuring clauses. The Supreme Court held that in order to arrive at consistency, whilst acknowledging that the trends clause calls for an inquiry into what financial results would have been but for the occurrence of the insured peril, held that they should be so construed that absent clear contrary wording, the trends clause arrived at the results that would have been achieved but for the insured peril and circumstances arising out of the same underlying or originating cause. Therefore, the trends and circumstances that should be eliminated by a trends clause were those unrelated to the insured peril. It follows that in assessing the amount of the indemnity, the first step is to identify which of the policyholder's activities were interrupted by the insured peril. Secondly, to identify the income actually earned from those activities interrupted by the insured peril during the indemnity period. And that amount is then compared with the standard turnover, adjusted to take account of any trends or circumstances that affected those activities before the occurrence of the insured peril, or that would have affected them but for the insured peril, which do not arise out of the same originating or underlying cause as the insured peril, namely COVID. Very briefly, pre-trigger losses. The court below held that pre-trigger losses due to COVID, for example, a reduction in turnover due to government advice to stay at home, which would have continued but for the trigger, was a required adjustment under the trends clauses. The Supreme Court disagreed. The court had correctly concluded that losses should be assessed on the basis that there was no pandemic, and consistently with that conclusion, in calculating loss, the assumption should be made that pre-trigger losses caused by the pandemic would not have continued during the operation of the insured peril. Finally, I might conclude by referring to the Orient Express case. The Supreme Court turned to consider this case, and in that case, the Commercial Court had considered an appeal under Section 69 of the Arbitration Act 1996 against an arbitral award in respect of an insurance claim for BI losses arising from damage to a hotel in New Orleans caused by wind and water as a result of Hurricanes Katrina and Rita in 2005. Time doesn't permit me to consider it in detail, but a point worthy of note is that the arbitral tribunal included Mr. George Leggett, Queen's Counsel, Lord Leggett as he was by the time of the Supreme Court decision, and the judge who heard the appeal was Mr. Justice Hamlin. They were therefore in the somewhat interesting position of having to explain, if not excuse, why they had both previously been mistaken. It is perhaps encouraging to us all that even justices of the Supreme Court make mistakes and subsequently have to explain them. Fortunately for the rest of us, we do not have to do so in a test case reported in the law reports. Thank you very much indeed.
Right, thank you very much, Andrew. I will take over from there. I'm going to put a document on the screen very shortly. I just start by saying, in light of Andrew's last comments, there's a well-known description of judges as law students who mark their own exam papers. And speaking as somebody with nearly 4 decades experience of marking students' exam papers, I find it interesting when I try to mark the judgments of the Supreme Court and others. I find it interesting to note the way in which in recent years, the Supreme Court has made its judgments more like general student theses, high quality student theses for the most part. And certainly it's true here and in 1 or 2 other cases that I've been dealing with recently, that they make a real effort to do more than just decide the case that is before them and to discuss the matter much more in the round. And I find that a very welcome thing for them to do. Let me move on to what I want to say. I'll put this document on the screen. This is going to be circulated afterwards. I want to do a couple of things in the time left to me. I want to talk about things that have happened since the judgment was handed down, and in particular things which the FCA has done. And if there's time at the end, I might add just 1 or 2 comments of my own about the position in relation to causation, where the Supreme Court's observations in this case seem to me to have implications which go rather beyond insurance policies. So, in the light of the Supreme Court decision, the FCA has published some guidance which may be helpful to policyholders and those acting for them. The documents are all on the FCA website, and if you're interested in this area of the law, then that's certainly a site that you need in your bookmarks. I will mention here the major documents that have been put on, and I'm going to talk in more detail about at least one of them. Firstly, there's a policy checker and a set of frequently asked questions which aim to help you find out if your policy is likely to cover business interruption losses. Interactive checklist, you can run through it, it asks you various questions, and when you answer them, it provides you some guidance about whether you are likely to be covered. Now, I stress the word likely. This document is not meant to be definitive, but it's certainly worth using as a starting point. And then the second document that I want to talk about rather more is there's a document which they describe as final guidance for policyholders on how to prove the presence of coronavirus. And there was a question in the chat a few minutes ago about this that I want to start to address now. The document runs to 30 pages, and I'm certainly not going to go through every single part of it in this talk. We'd be here all morning. But there is a section, section 2, which is aimed to provide guidance and assistance for policyholders. And it's not particularly long, and I do want to summarize what it says, because I think it's likely to be helpful to you. If you're acting for policyholders in cases of this kind, I think you will want to look at that chapter 2 and run through the steps which it invites you to take. It's guidance, again, it doesn't, strictly speaking, have the force of law, but it seems to me that if you can go through the guidance offered in this chapter and you can demonstrate to the insurers that you can meet the requirements which the FCA suggests, then your insurer is going to have more than a little difficulty in rejecting your claim. So, we start by saying that, as we know, some policies require the policyholder to prove the presence of disease within a particular area. And that's what this bit of the guidance is aimed at. You start by asking yourself these questions. Have you got a policy which does one of the following things? Requires the presence of disease within a particular distance or zone or radius from the premises. And we know that many of them do. 25 miles is a common radius in these policies, but there are some that have a radius of just 1 mile. Does it alternatively require the presence of disease within a vicinity or area where events that occur within that area would be reasonably expected to have an impact on the policyholder? The disease clause in RSA type 4 is an example of that. Or does it, as a further alternative, require the occurrence of a notifiable disease without specifying a particular vicinity or area within which the disease needs to occur? Now, that I think is going to cover most of the cases with which we, and probably most of you, are likely to be concerned for present purposes. If your policy contains any one of those types of wording, then the FCA offer you guidance on the steps you should take to prove the existence of COVID. The particular radius, the 25 mile or the 1 mile, or indeed anything else, referred to in this as the relevant policy area. Usually, you will need to prove that a case occurred at any time prior to the interruption of the business. And that's a simple causation point. How can the interruption have been caused by the case if the case only happened later? You need to explain then which type of evidence you've got, how you've got it, and how it proves the presence of at least one case of COVID in the RPA. In those cases which have the 25-mile relevant policy area, the FCA suggests that you try to use these types of evidence, and they're listed 1 to 4, and they come in this order. The FCA suggests that you use them in this order, implying that number 1 is more convincing than number 2, than number 3, than number 4. Number 1, specific evidence. And they give us the example, media reports of a case near the premises. So clearly, if you can find in the local newspaper an article about the occurrence of COVID within the relevant area, that's we'll regard it as pretty strong evidence. And local papers, I think, certainly based on my experience of local papers around Leeds, where I live, have been very keen to report cases which have happened. If you haven't got that, category 2 is NHS data on deaths due to COVID-19. And of course, there's lots of data. It's on the Gov.uk site, it's on the PHE site, it's on the ONS site, and also on the NHS site. That's a whole mouthful of initials, but all those organisations have their own websites, and you can fairly readily find on there the relevant pages which contain information on the deaths broken down by area. And you may well be able to show from that that there is pretty strong evidence that there must have been at least one case of COVID within your relevant policy area. National ONS data, Office of National Statistics death, that's listed actually separately as category 3. The ONS, I think, are not quite so good at breaking these things down geographically as the NHS are, but there may still be sufficient information on there to enable you to provide adequate proof of the existence of COVID within your relevant area. I would just pause to observe that I don't find the ONS site particularly easy to use. I think the NHS site is much easier. However, it's listed by the FCA as the 3rd category of evidence that you might use. And the 4th category, the weakest of the 4, reported cases of COVID-19 in different areas, for example, local authorities. If your local authority have produced figures for their own area, then that may be of some probative value to you as well, though there is this problem that the local authority area may extend beyond your relevant policy area. And it may be therefore that merely to show that the figures for, well, let's take the extreme example in England, the figures for Yorkshire, the biggest county, that won't necessarily prove that you had an outbreak in Leeds. So its probative force may be less. And that, I suppose, it's why it's listed as the 4th category rather than being listed any higher. And then the FCA go on, and you can see as we go down through this that the evidence is getting more difficult and perhaps less satisfactory. They contemplate next the situation where none of these 4 types of evidence is sufficient to prove COVID in the relevant policy area. And they say, for example, because it has data for cases which could be inside or outside. And that, as I indicated a minute ago, it seems to me is particularly relevant in category 4. But then they say, well, there are 2 other methodologies which are much more inferential, I suppose is the word to use. One is to say using an undercounting methodology in recognizing that testing was limited before the first national lockdown. And that requires you to use statistical models to estimate the real number of infections in an area. And if that doesn't make sense to you, well, let me remind you of something that happened at an early stage of the pandemic. From a very early stage, figures, particularly figures on the Gov.uk site, have reported the number of cases day by day. But in the early stages particularly, a lot of people thought that that was very considerable underreporting. There were people arguing that the true number of figures could be anything up to 3 times the number being reported. And that was because, to begin with, the level of testing was relatively low. We're used now, I think, to the idea that we probably test somewhere between 1.5 and 2 million people a day. In the early days, we struggled to get up to 500,000 tests a day. Secretary of State for Health promised that that was going to happen at a very early stage, and his promise was by no means fulfilled. So it would be possible to argue that right back at the beginning, there was legitimate reason to think that there were far more cases than were actually reported, and that on that basis, you could say there's a good chance that there were cases in your area. If you think that's a bit wing and a prayer, well, I rather agree with you. And the guidance, I think, recognises that it's a very imperfect way of going about it. It's suggested as almost a last-ditch alternative if none of the first four methods works. And the alternative way of doing it, the final alternative way of doing it, is statistical again. It's what they call the geographical distribution methodology, where actual or estimated infections are averaged across an area, weighted according to population size. That if you can say that the evidence is, I don't know, 500,000 cases in Yorkshire, and you want to know how many cases there were in Leeds, well, you can ask yourself what proportion of the population of Yorkshire lives in Leeds and use that for saying that's a reasonable estimate. And that shows that there really must have been cases in Leeds. I don't think Leeds is a particularly difficult example. I pick it because it's where I live. But you see the point that's being made. Those last two approaches don't go about pointing to particular cases in particular places. They take it from larger areas and they make certain statistical assumptions which you can argue are justified. I think it's fair to say that the guidance here implies that those are much weaker and insurers may be much less inclined to accept them. But if you can get within the first four categories, I don't see how insurers really can hope to get away with not accepting those. I'll just deal briefly with the other two things. It was the proof points that I wanted to deal with particularly. Lists of policies assessed by insurers as in principle capable of responding. There's a 3-page list of standard policies from different insurers which they've assessed as being in principle capable of responding. That may save you a certain amount of work. If your policy is on that list, well, you're, if not halfway home, then at least a quarter of the way home. But of course, it's general guidance. If you're not on that list, that's not fatal because it's still a matter of the policy wording. And even if you are on the list, there's always the risk that you can't show that it works in your particular case because you can't satisfy the proof requirements, or that there are particular modifications to your particular policy. And finally, there is their FCA's Dear CEO letter dated the 22nd of January. And I put in there an extract from it. It's a 5-page letter. It talks about the need for insurers to act promptly to make sure that valid claims are met. It suggests that the court have provided sufficient guidance and that insurers are expected to deal promptly and not allow policyholders to be further disadvantaged by being kept out of their money. And as it says in the bit that's on the screen now, we expect all insurers to take a pragmatic, transparent and consistent approach to their interactions with policyholders. Dealing fairly with policyholders is, of course, one of the principles upon which FCA regulated businesses are expected to operate. Right, finally, causation. This will have to be very brief because we are rather running out of time. And it's a bit more speculative than the rest. Andrew Grantham took you at some length through what the Supreme Court said about causation in the particular case, and I don't dispute anything he said. It's clear, well, I think it's clear anyway, that the Supreme Court were dealing with causation in the context of insurance policies. And the question that this put in my mind was how far we can use any of this for causation in other categories of case. Any of you who do any significant amount of personal injury work will know that there are many cases where you put in a claim and you find that liability is admitted, but causation, among other things, is disputed. And there are quite difficult questions about causation. Supreme Court start at page 160. They recited some of the historically important cases. Andrew Grantham talked about those, won't do them again. The bit I wanted to talk about was the but-for test, which is the one that we all learn, usually when we do an undergraduate course on the law of tort, where they say, and they say at paragraph 181 of the judgment, the main inadequacy of the but-for test isn't that it returns false negatives, but that it returns a countless number of false positives. That's why it's often correctly described as a minimum threshold of causation. And that arises, it seems to be, in the situation where you've got multiple concurrent causes, and also where you might want to go back a very long way. Would COVID have happened if whoever that person was in the laboratory in Wuhan hadn't acted as he did? Well, no, certainly not. But to say that that's the effective cause because it passes the but-for test is obvious nonsense. So you can have things that pass the but-for test but are not to be regarded as causation. And that's why in paragraph 191, they have the paragraph which I've set out there. Nothing in principle, the concept of causation, which precludes an insured peril that in combination with many other similar uninsured events brings about a loss from being regarded as a cause, indeed as a proximate cause. And that's the point about how all the cases taken together led to, for example, the imposition of restrictions, even if none of them did. And it led me to think about how the but-for test works and how causation works, particularly in the law of tort. It seemed to me that as long ago as 2002, in the Fairchild case, similar sort of argument was used to finesse difficulties of proof, where it's not possible in some of the asbestosis cases, for example, which was perhaps the most common phenomenon of this, not possible to show which employer was immediately responsible for the injuries, where you had a claimant who might have worked for, I don't know, 13 employers over the years. He ended up with mesothelioma, and the question was which employer was responsible for it. And the House of Lords, as it then was, said, well, we can treat every single employment as being a concurrent cause of this, and that means that all the employers are potentially liable. And that seems to me quite a sensible approach to take. It's interesting to see it being adopted further in the context of insurance policies here. It does mean, I think, that we have to be increasingly skeptical and cautious about just applying any kind of but-for test. There's a lot more to causation in a legal sense than that. Okay, I've slightly run over time, but never mind. I hope it's been useful to you. I'll take this document off the screen. It will, as I say, be circulated. I think it's probably time to stop here and to invite questions from the floor.
I can't see any questions on the message board that haven't already been answered. I just make one observation in response to what Andrew said. I think Andrew's analysis is exactly right. I think there are wider implications for causation, specifically in tort law, but also in any area where one is trying to prove loss or claim damages where there are concurrent causes. I think but-for causation is neither a necessary nor sufficient condition to establish causation any longer. But I suspect that in the majority of cases, it's a good rule of thumb as a starting point, and that's about as far as one can go. I don't know what you think, Andrew.
Yes, I agree. I spent many years teaching students that it's the but-for test in Barnet and Kensington and Chelsea Hospital Management Committee. But it's clear with these recent cases that won't do. As you say, a minimum starting point perhaps, but no more than that. There's much more holistic view, it seems to me.
We're agreed. Good. I think we have a question from Jamesh. May there be an issue in relying on policies where they list an exhaustive list of diseases? Well, the short answer to that question is yes. It depends what's on the exhaustive list. In the policies that are under consideration or the disease policies that are under consideration in the Supreme Court, they all refer to notifiable disease. So there was no need to consider whether a COVID was encompassed within a specified list of diseases. So I think the answer is yes, it will depend upon the list of diseases in question. Are there any other questions? I think not. Well, all I'd like to say then is if you do have any questions for either Andrew or myself, certainly I can say for myself, we'd be delighted to answer them by email or any other means. And if you want copies of our notes, I believe they're going to be distributed. And thank you all very much indeed for attending this morning. I hope it's been of some use to you. Thank you very much.